Welcome to the Idaho Debates, a look at the candidates on the general election ballot for the Idaho Supreme Court. The Idaho Debates is a collaborative project of the Idaho Press Club, the League of Women Voters of Idaho, Boise State University School of Public Service, and Idaho Public Television. The Idaho Debates are brought to you by contributions to the Idaho Public Television Endowment.
Hello and welcome to the Idaho Debates live from the Idaho Public Television studios in Boise. This is our first and only debate of the season, but it's a good one, and it's the only televised debate with the candidates vying to be the state's next Supreme Court justice. A Supreme Court justice in Idaho is one of 5 people who will work as the ultimate and final legal authority in the state. They have the last say in Idaho legal matters and work as administrators of the entire court system. Their duties are primarily the execution of fair, impartial deliberation and rulings on some of the most difficult legal questions in the state, protecting equal access to justice and protecting the constitutional rights of the people of Idaho. Tonight, we welcome the 2 individuals who are asking for your vote. Robyn Brody has practiced law in the Magic Valley for 20 years. She has served as the president of the 5th District Bar Association and the Idaho Trial Lawyers Association. She graduated from the University of Denver College of Law and is a solo practitioner at Brody Law Office. Curt McKenzie graduated from the Georgetown University Law Center. He worked 1 year in the Ada County Prosecuting Attorney's Office and 6 years in civil litigation at Stoll-Reeves before opening McKenzie Law Office. He served 7 terms in the Idaho State Senate, was on the Public Defense Reform Interim Committee, and was the president of the Pacific Northwest Economic Region. Also on stage with me is our panel of reporters selected by the Idaho Press Club. They will ask the candidates questions tonight: Betsy Russell of the Spokesman Review and Rebecca Boone of the Associated Press. I'm Melissa Davlin, co-host of Idaho Reports here on Idaho Public Television. I'm moderating tonight's debate and will do my best to make sure all candidates get equal time and stay on point. To remind the candidates how long they've been talking is Eleanor Chahy, volunteer timekeeper from the League of Women Voters. We've asked the candidates to engage each other on the issues. In other words, less emphasis on a rigid format and more focus on an intelligent discussion that helps you, the voter, cast a more informed ballot. Each candidate will be given 1 minute for opening comments and 1 minute for close. We flipped a coin a few minutes ago to see who would go first, and Senator McKenzie, that honor goes to you.
All right, thanks, Melissa. Thanks for our hosts, and thank you for watching. I'm Curt McKenzie, and I believe I'm the right choice for our Idaho Supreme Court based on my judicial philosophy, my education background, my broad work experience, and my record of public service. My judicial philosophy is a simple one: apply the Constitution and statutes as they're written. My education is rooted here in Idaho. I'm a 3rd generation to go to NNU. Then I went to Georgetown and studied law. From there, I've worked for large national law firms doing complex civil litigation. I've prosecuted crimes on behalf of Idaho, and I've had my own practice representing individuals and small businesses. I'm proud of my record of public service in the Idaho State Senate. Idaho has a long tradition of justices having public service in the elected arena, and I believe it is an asset for the court. Again, I'm Curt McKenzie, and I'm asking for your vote on November 8th.
All right, thank you. And next we'll hear from Robyn Brody.
Since this race started, I have spent countless hours in the car. I've traveled more than 28,000 miles all across this state. People have invited me into their political meetings, into their business rooms, their business board rooms, into their hospitals, into their churches, their libraries, and even into their homes. I've had the chance to listen to the people of Idaho, and I've also had a chance to talk to them and educate them about the Idaho Supreme Court and what we do and what we don't do. The Idaho Supreme Court is the final decision maker on the Idaho Constitution, on Idaho law. They manage the system. We manage for the entire state, the entire judicial system. But what we can't do is change those decisions that are made by the Supreme Court of the United States in Washington, D.C. We're in charge of the Idaho Constitution, our right to bear arms, to hunt, to fish, and to take care of victims' rights. Those are the things that the Idaho Constitution and the Idaho Supreme Court can protect.
All right, thank you so much. And the first question will come from Rebecca Boone.
Senator McKenzie, you've both said that judges need to follow the law regardless of public opinion. And Senator McKenzie, you just mentioned that you favor a more textualist approach. that is, applying the plain language of law to a legal question without undue regard for the result. Do you think there's ever room for a more Aristotle-influenced approach to law, where you might consider what a reasonable legislature may have intended?
Thank you for that question. I believe that question really addresses that fundamental issue of separation of power. And it's those cases where you talk about where a justice may want to do what they believe is right in a particular situation, that they're most likely to want to try and interpret the language in a way that they think produces the right result, even if it doesn't quite do justice to the text. And those are the circumstances where I believe it is fundamentally important for a justice to apply the text of what's written, and to do so applying the language as it was understood at the time the Constitution was ratified or the statute was passed.
So what then happens when the Constitution or existing case law suggests a legal result that would be unequitable for the parties or is offensive to modern societal norms? And as an example, I'll just point out that Idaho's Constitution made it illegal for Mormons to vote until about 1982. And also many of our transportation laws were written before driverless cars were even considered as a possibility.
Right, so our Constitution can be amended over time. And in fact, in Idaho, over 130 times the people have gone back and amended the Constitution. And it's their right to do so. But it shouldn't be up to judges, 3 judges, which would be a majority on our court, to set that policy. It's up to people to fix those inequities. And our legislature, which is elected to 2-year terms, is closely responsive to the people that elect them. They set the policy, and there are times when they need to go back and change that law, or the people will want to amend the Constitution, and there's a process to do so.
Okay, and Mrs. Brody, I'd like to ask you the same question. Do you favor a textualist approach, using the plain language to come up with a result, or do you take the approach of trying to interpret what a reasonable legislature may have done or intended when they created a law?
I think the good and faithful judge is one who looks at what's written, what's there in black and white, and even when it means that you don't like the result, you've got to understand that line. Now, let me be clear, judges still judge. And judges judge every day, even sometimes in the statutes that are passed by the legislature. I'm thinking now about an attorney's fee statute in Idaho that allows for judges, or actually tells judges, that they may award fees. And so, of course, it's going to be up to the court to decide when are the right circumstances. Judges are not we're not automatons, and we don't make decisions with simple data in and data out. At the end of the day, judges judge.
So as a follow-up, I think actually earlier this year, the Idaho Supreme Court was remanded by the U.S. Supreme Court, told to approach the way it awards attorney fees differently because apparently it didn't jive with some federal case law. Is there ever a point where you move away from the textualism of the state constitution in trying to incorporate case law as it's being interpreted by other courts, other judges who may take a different judicial philosophy approach?
Well, you've always got to use common sense and be able to address new situations that the Constitution didn't envision. I mean, certainly none of our founding fathers envisioned text messaging as a form of communication, but certainly we have it today, and you've got to be able to do that. I mean, even Justice Scalia would tell you, you've got to use your head, and nobody's suggesting that you don't. But you've got to be very careful and understand that at the end of the day, when it comes to making policies, the role of the legislature is critical, and the court should not be the one that's setting the policies for this state.
So, Mrs. Brody, and really this question is for both of you. If you were on the Idaho Supreme Court in 1980, 2 years prior to the voters removing that clause from the Idaho Constitution that forbade Mormons from voting, would you have felt it was your duty to enforce that ban on citizens of Idaho who were of the Mormon faith from voting?
You know, we'd have to look carefully at the precedent, at the court decisions that had been made before then, at the text, at all of the tools that judges have in order to make decisions. And I can't tell you what I would do then or even now if the issue were to come up, because we can't really tell people or the positions that we would take on given issues. But I will tell you that you have to look, judges have lots of tools available to them. Precedent, and they have the text and what's there in black and white. And they have constitutional amendments as well.
Senator McKenzie, same question.
Is looking at that issue, the due process clause of the 14th Amendment protects those types of rights that were traditionally recognized at the time it was ratified. Applying it to this issue, along with the First Amendment, for people's right to vote as well as to practice their religion of choice, I believe that it was likely the court would have looked at that issue under the 14th and First Amendments of the U.S. Constitution and determined that that was a fundamental right that they would have had at the time.
Senator McKenzie, you've previously mentioned Roe v. Wade as a Supreme Court decision that deviated from your judicial philosophy, and you have an endorsement from Idaho Chooses Life. If you were elected to the High Court, where would you draw the line between upholding your personal beliefs and following the legal obligation to uphold case law as it's been set by the U.S. Supreme Court?
Well, thank you, Melissa, for that question. And it's a job of a justice to apply the law. And under our system of federalism, that includes the decisions of the U.S. Supreme Court. I'm proud of the endorsement. I'm proud of the bills that I've worked on as a state legislator. But I'm also bound by what comes out of the U.S. Supreme Court. Since the 1960s, under the due process clause that I mentioned, under substantive due process, the court has expanded rights that beyond what were enumerated in the Bill of Rights. They've done so in a number of cases, and we are bound by those decisions regardless of our personal preference. I think it is the role of a justice to apply the law impartially without personal bias.
And Mrs. Brody, I'm curious how you interpret the Supremacy Clause, specifically in instances where federal precedent conflicts with the state constitution.
Well, you have to look at the specific issue that's coming before the court. One of the things that's very interesting about Idaho law is when you take a look at the Idaho Constitution, we have constitutional language that in many arenas may actually provide greater rights to litigants than maybe the federal Constitution. And the Supreme Court of the state of Idaho can always provide more protections to the citizens of Idaho than the federal Constitution. But at the end of the day, if we're talking about federal law and the federal Constitution, that's what my opening statement was all about. People think that the Idaho Supreme Court can change, or have the impression that they can change the decisions that the Supreme Court of the United States makes. And that's what we can't do. But we can interpret our own Constitution.
All right, the next question comes from Betsy Russell.
Mrs. Brody, speaking of interpreting our own Constitution, that is, of course, exactly what the Idaho Supreme Court does. And Governor Otter has said recently that the current education system in Idaho is probably not up to constitutional muster. The Idaho Supreme Court ruled in 2005 that the funding system was not sufficient to carry out the legislature's duty under the Constitution. And the legislature is reevaluating the funding system as we speak, but it has been more than 10 years, and the court has permitted, despite its ruling, an unconstitutional system to persist. Should the Idaho Supreme Court have been more active in protecting the Constitution like the Washington Supreme Court did in a similar school funding case, or do you believe that there are simply some parts of the Constitution that the court can't or shouldn't enforce?
You know, Betsy, as a mom, that education is something that goes straight to my heart, and is something that all of us here in Idaho are struggling with. The reality is that the litigation over the Idaho school system has been going on since the 1970s. It's been going on that long. And I can't give you an explanation for why the Supreme Court in 2005, when it retained jurisdiction over the educational funding case, why it suddenly reversed itself and made the decision to stop the litigation. Of course, we know since then there was another effort where the Supreme Court justices themselves were actually sued in federal court over the entire thing. It's an incredibly difficult issue, and there are a lot of interesting things that are going on in other legislatures or in other states in courts over this. But at the end of the day, it comes down to this. Courts have a very difficult time providing remedies when either the executive branch or the legislative branch doesn't listen. I go back to the days of Andrew Jackson, when there was a Supreme Court decision in which they found that he was violating the Constitution by a particular law that required settlers to leave Indian Territory. And his comment was, well, Justice Marshall, you've made your decision, now enforce it. And the point is this, at the end of the day, the courts don't control the budget. They don't control the decision making at the top.
Senator McKenzie, same question. What is your view of how the Idaho Supreme Court handled that school funding case, and whether we are allowing a school funding system to operate in a way that does not meet the requirements of our state constitution?
When you mention the Constitution, under Article 9 of our Constitution, it's a general, thorough, uniform system of schooling, and there's a long line of case law addressing whether we are doing that, and I assume that will continue over time. I have served in the Pacific Northwest Economic Region with Senator Kevin Ranker from Washington, who works on the Budget Committee there. And the state Supreme Court there, I believe, had fined the legislature until they'd complied with what they thought were their constitutional duties. And so the body that actually sets the budgets and appropriates monies both for the other branch and for any fine was ordered to pay a fine. I don't think it really changed anything there. But it is the duty of the court to apply that constitutional standard to our education system. And while I've been in the legislature, we've worked on that issue. My first term there, which was the longest in state history, we put in place PSIF, the Public Education Stabilization Fund, to help address those situations where the economy really tanks again, and to have that funding there. That was a part of a solution. We've worked on setting aside maintenance funds for our school buildings. And I believe since we did that, we've given the school districts discretion to use those funds in other ways because they've needed to be able to do it. But when it comes back to the court and their role with respect to the legislature about whether we're meeting that constitutional standard, it's the role of court to evaluate that in specific situations that are brought before the court, and I am confident that we will see those again, and to make a declaration of the Constitution whether we're complying with it or not. And beyond that, I don't know if I can comment about what a future court would do with respect to a situation where it didn't think it was complying, because I do think that's something that's going to come up.
All right, I have a question moving on to another topic for you, Mrs. Brody. And so you in recent years have litigated some pretty contentious issues involving water law and water rights before the Idaho Supreme Court. And in some cases, the Idaho Supreme Court ruled against your client. As a justice of the Idaho Supreme Court, do you think you would be bound by these prior decisions, even if you thought one or more was incorrectly decided? Would you seek to reverse or overrule these decisions, or would you have to recuse yourself from water issues altogether?
I think it really depends on the issue that's coming before the court. You know, there is nothing quite like water in Idaho to really get people's passions going. Those are complicated decisions. Some of those decisions would not have any application to any litigant in the universe other than my client. Some of the decisions related to, for example, the Eastern Snake Plain Aquifer model that's being used for delivery calls in southern Idaho. I suppose if something were to come up that dealt with the validity of that model, and maybe if I had information that might bear directly on the issue, it would be something that I'd have to look at carefully. But it's one of those things, in terms of conflicts, I think every time we look at a case, we've got to look at the parties, the attorneys, the issues, and make a case-by-case decision as to whether we can actually sit.
And taking a step back, and this question will go to both of you, but I'm curious, you both have experience with water issues. Mrs. Brody, what is the role of the Supreme Court in resolving water rights disputes, and should the Idaho Supreme Court give deference to decisions of the Idaho Department of Water Resources because of the specialized knowledge that is contained within that department?
Well, the number one job of the Idaho Supreme Court when it comes to water is to uphold the Constitution, period. Then you look at the Idaho legislative laws that have been passed. And in terms of agency deference, it really turns the Idaho Supreme Court's ability to review what an agency does, whether it be the Department of Water Resources or any agency, the Department of Insurance, it doesn't matter. It really turns on what you're looking at. If you're looking at factual issues, if you're looking at places where the department has particular expertise and you're talking about fact-specific types of issues, those are very hard for the Supreme Court to step in and to judge or reevaluate those facts, to second guess, if you will, the legislative agency, the executive agency. But on the other hand, if you're talking about the law, that's a whole different matter, and that's an area where the Idaho Supreme Court can use its powers to review what's happening.
Senator McKenzie, same question to you. Should the Supreme Court give deference to decisions by the director of IDWR?
I believe that the court's role is fundamentally to protect those rights as they're expressed in our state constitution. I think we need to be careful about deferring to an agency in this regard or others, because we've seen the federal model where the legislature, Congress, has deferred broad rulemaking authority to agencies, and then courts have deferred to their expertise, allowing much of that policymaking authority that had been exercised by Congress to now be exercised by agencies. In this regard, in water issues, I would say Idaho is ahead of most of the West in how we deal with water. But we do have a fundamentally important issue, which is that Snake River aquifer, the decline of that aquifer, and the historic agreement that was entered this spring between the groundwater users and the surface water coalition. And I believe that parts of that agreement that are set to be implemented over a number of years could very well work their way up to the court. And I would see my role with respect to that or other water issues is to apply the language as it's written and allow that and within the constitutional framework to define what those rights are.
Next question comes from Rebecca Boone to Senator McKenzie.
Senator, you've never argued a case before the Idaho Supreme Court or the Idaho Court of Appeals. Why do you think you're ready to sit on the highest bench if you've never stood in front of it?
Well, thank you for that question. Well, my experience has been in front of our district judges or our magistrates. Those are the courts that most people see. They're most familiar with those courts or specialty courts like Veterans Court, Mental Health Court, Drug Court, where I have spent hours in front of them. As an attorney, I have filed appellate briefs when I was with Arter and Haddon in Washington, D.C. We had some appellate work at Stoll-Reeves. But the legal analysis that I did on those cases, the kind of complex civil litigation that we practiced there, the extensive brief writing that we did, is all important background for someone who's going to be on the court. But I also think it's just as important to have a justice who has extensive experience actually practicing in front of those district judges and magistrate judges who are the ones that most people are going to be in front of.
Mrs. Brody, You have argued many cases before the Idaho Supreme Court, but nearly all your professional experience appears to be in civil cases, not criminal. Do you have what it takes to be part of the team leading Idaho's criminal courts?
You bet. And I'll tell you the perspective that I bring to the bench that's different than what's there. I look at this job as being part of a team. You're not a lone decision maker. You're working with 4 other people to make the best policy decisions that are possible. And it's true, I'm not a criminal defense attorney by any stretch, but I certainly have a great deal of experience actually working within that system and working with people who have been the victims of crimes. And I think that that's a perspective that's valuable and important and different than what's there now. I'm thinking of the 3 judges that we have there now, Burdick, Eisman, and Justice Horton, all incredibly experienced district court judges who come with tons of background and experience in the criminal matters. But to have a different voice, to have a different perspective, I think that's incredibly important.
And Betsy, you had a follow-up?
Yes, Mrs. Brody, what do you think of Senator McKenzie's statement that he has practiced before district and magistrate court judges, and that's what most people in Idaho see, so that's sufficient experience to go before the Supreme Court or the Court of Appeals?
You know, we've traveled a lot together over the past 7 months, and we've listened to each other talk. And when it comes down to how we interpret a statute or how we might approach a constitutional question, I don't know that Mr. McKenzie and I really differ in that regard. I mean, the things that he's talking about, textualism and originalism, I mean, those are things that are bred into us in law school. I mean, that's the way we approach legal questions today. We ask, what does the statute say, not what do we want it to say. That's how we do it. But I'll tell you the thing that really makes me different from Mr. McKenzie, and that's 20 years of experience litigating in front of county commissions, planning and zoning, magistrate court, district court, the Supreme Court 9 times, talking about getting an incredibly broad and deep perspective on the legal issues that affect the people of the state of Idaho. I'm talking about taking 20 years of being in the trenches. I've had one job my whole career, and that's taking care of people's problems in the courts and talking about what the law is, what the policies are, and making excellent decisions. And I think that voice, that experience is incredibly important. And the fact that Mr. McKenzie has never stood in front of the Idaho Supreme Court is something that concerns me greatly.
Senator McKenzie, why haven't you argued a case before the Supreme Court or the Court of Appeals prior to seeking a seat on that bench?
Well, my practice has just been in either federal courts, mostly at Stoll Reeves. We were often in federal courts or out-of-state courts representing a company based in Idaho that had business across the country. And then most of my experience in practice at my own firm has been at the trial level. And so I have that extensive experience, and I think it's a useful experience. But I would say what I look for in a justice is not simply that you've argued a few cases before the Supreme Court, but that fundamental judicial philosophy that's going to inform all your cases, whether it's a constitutional issue or a statute or an agreement, that you will apply the text as it's written. And I would do that. And I'd also say that, you know, my academic background at Georgetown University, attended on a full tuition scholarship on a year that they had more applicants than any law school in the country has ever had. Graduated in the top 10% of my class there. Is a strong background. I understand the law. I can apply it, and I'd serve Idaho well on its court.
All right, the next question on pro bono work comes from Betsy to Senator McKenzie.
Senator McKenzie, this is Pro Bono Week. Idaho's rules of professional conduct say that lawyers should aspire to perform at least 50 hours of pro bono work every year. And both of you have maintained that you do more than that. Yet, neither of you have reported that time to the Idaho Volunteer Lawyers Program. If you are elected to the High Court, you'll be able to help create pro bono programs and make sure the state is working to meet the legal needs of low-income clients. So do you think that Idaho's pro bono tracking and reporting systems need to be more robust so that we can all get a better understanding of the need for reduced fee legal work versus the actual supply of volunteer lawyer time? Or would a reporting requirement just be too oppressive for busy attorneys?
Thank you. You know, I wouldn't add to the reporting requirements of attorneys because practices differ so much. From when I was at Stoll Reeves, a law firm of hundreds of attorneys, to having a solo practice representing individuals and small businesses. They're very different practices. Some attorneys like me serve in other capacities. I'm in the legislature 3 or 4 months out of the year, depending on if we can set a budget or not. I've got interim committees, and so attorneys have obligations, and many of those are in public service that aren't necessarily pro bono. And so I wouldn't require attorneys to have additional reporting requirements, but I do think it is important that we continue to emphasize access to the courts, in which pro bono work is part of that.
Mrs. Brody, same question.
You know, I learned something. I learned something in this campaign, and that is I didn't realize I was supposed to be reporting hours to the Idaho State Bar or to the Volunteer Lawyers Program. When I've participated in that program, I've reported the hours. But in terms of the hours that I spend taking care of my neighbors and community members, no, I've never reported them to anyone. But I'll tell you, for me, what's important. As I've traveled around this state, I've seen what lawyers are doing. We have people working in every community providing services. When I was up in Bonner's Ferry, the Idaho Legal Aid was advertising a free day where you could come in and have a time set aside to meet with an attorney to discuss your legal matters. The Idaho trial lawyers here in Boise, they provide the street law clinic. There's a program similar to that in Twin Falls. And what I see from traveling around is that the first thing we need to do in this state is gather up all of the assets that we have, all of the people who are providing those services. Let's get them put all in one place and coordinated so that everyone knows that those services are available. What I'd also love to do is I would love to see, a website, something like Free Legal Services for Idaho, or I don't know the name, but the point is this, where you can catalog all those services that are available, where you can take the forms, the interactive form services that the Idaho Legal Aid Services has available on their website, put them on there. The Idaho Supreme Court has forms available. Let's make them interactive. Let's put them on all a single website. I'm talking about just common sense. I'm talking about gathering up all the resources that we have, putting them in one spot so that the people of the state of Idaho can access them.
All right, the next question is coming from Rebecca Boone.
The Idaho State Bar sends a survey to members to rate those running for the Idaho Supreme Court. And they rate them in 4 categories, including integrity, knowledge of the law, temperament, and legal ability, on a scale of 1 to 4, with 4 being the highest. Ms. Brody, you averaged a score of 3.65 in the latest survey, while Senator McKenzie, you averaged a 1.86. So to both of you, and I'll start with you, Mrs. Brody, how much weight should voters give these scores?
I think they're incredibly important scores. People ask me, when I'm out there on the campaign trail, the first thing they ask me is, do we really vote for our Supreme Court justices? And the next question they ask me is, what makes a good one? And that's such a hard thing for people to evaluate. And I'll tell you what, as much as we all love to tell a good lawyer joke from time to time, the lawyers of this state know what judges do, they know what's important, they know how to evaluate it, and they've done that. Those scores mean something, and I hope Idaho voters will take a look at them.
Senator McKenzie, would you like to respond?
Sure. Yeah, I would say it doesn't surprise me that lawyers tend to lean towards someone who had served as president of the Trial Lawyers Association over someone who most of them know only as a conservative Republican state senator. Last year, Harvard Law School did a survey of the ideology of American attorneys, and they published it last year. What they called the most comprehensive picture of the ideology of American lawyers ever assembled. And here's what they found, and I've got the study here, but just quoting from their conclusions. First, American lawyers lean to the left of the ideological spectrum. The model score places the average American lawyer's ideology close to the ideology of Bill Clinton. This confirms prior scholarship in journalism that has argued that the legal profession is liberal on balance. Now, I don't know Mrs. Brody's personal preferences. She doesn't discuss it on the campaign trail. But I would expect the attorneys and that bias to be reflected on an anonymous survey of someone who was president of the Trial Lawyers Association versus someone who is a conservative, has a record as a conservative Republican state senator. In fact, when you look at the survey results from 2010, the ratings in this race are higher than any person who has applied to that court, including 2 of the sitting justices, as well as several district judges that I have sat in front of. I am proud that those that I work the closest with have supported me. Every member of the majority leadership team that has served on State Affairs Committee, which I chaired, has. Every member of the House leadership team as well. And so I'm proud for those endorsements, but I do think you need to look at people's inherent biases when they fill out an anonymous survey.
And Mrs. Brody, I want to give you a chance to respond to that. But first, Senator McKenzie, I want to touch on one of the things you've said. You've posted endorsements from 44 current or former lawmakers on your campaign site, and all of them are Republicans. You've mentioned repeatedly that you have a reputation for being a conservative Republican. You have endorsements from the NRA and Idaho Chooses Life. So are you properly running for a nonpartisan office with all of these endorsements that you have been touting?
Well, Melissa, thank you. And I'm proud of those endorsements, but I also have endorsements of members of other parties that I've worked with. As president of Penware, our leadership team was made up of, I was the president from Idaho, but leaders also from Oregon, British Columbia, and Montana. And the 3 members who served as vice presidents when I was president of that organization have all endorsed me, and they are from 3 different political parties. Senator Robyn is a Democrat from Oregon. Mike Cuff is a Republican representative from Montana. And Dan Ashton was an MLA from the British Columbia Liberal Party. They've sent a letter to the newspapers across the state, and I'll just read a brief portion of that. But they wrote, we're members of 3 different political parties, but party affiliation was never an issue as we worked closely with Senator McKenzie to advance nonpartisan solutions to regional issues. Senator McKenzie's leadership was fair, open, and collaborative, and focused on advancing the best interests of our region. We're happy to call him a friend, and we believe that the qualities that made Senator McKenzie an effective and respected president of Penware will serve him well as a justice on the Idaho Supreme Court.
All right, thank you so much, Senator McKenzie. Ms. Brody, I want to give you a chance to respond.
You bet. The bar scores are what they are because I earned them. I earned them over 20 years. If you take a look at my service in the bar, every organization that I've been a part of, I've risen to the leadership spot. I've been the president of the 5th District Bar Association. I'm part of the Idaho Trial Lawyers Association, and I became the president. I was a member of the Theron W. Ward Inn of Court, a professionalism organization, and I became the president. In 2014, the bar honored me with a professionalism award. When people call me, and it happens virtually every day, they call or they email, they ask for my advice, they ask for my input. I'm talking about my peers now, people coming to me looking for knowledge and information. When people ask me to teach, I teach continuing legal education in any forum that they ask. I'm a mentor in the Idaho's Trial Skills Academy. I mentor young lawyers, those who are in practice less than 10 years, help them become better lawyers. People come to me because I give, because I serve. I try to provide them with the benefit of the knowledge and information that I've got. And we're talking about reputation, something that's taken me 20 years to earn. That's why the bar scores are what they are. It's not simply a reflection of bias, it's a reflection of people knowing me, and most importantly, trusting me.
The next question is coming from Betsy Russell.
Mrs. Brody, while you have received endorsements in this race from an array of individuals in Idaho from both political parties, state records do show that prior to your making this run, in past years, you did give political donations, partisan donations, and they were all to Republicans. How do you rise above your past partisan Republican ties to seek this nonpartisan seat?
Sure. I'm not apolitical, and before I sought this position, I participated actively in local politics. I've brought pies to the picnics, I've built floats, I've helped local candidates win races, to be sure. But you know, when it comes to this race, when I signed up for this, I knew it was nonpartisan, and I was happy to sign on for it. Because frankly, in today's world, I love the fact that in this race, I can reach across the aisle to Democrats, Republicans, constitutionalists, independents. It doesn't matter. The thing about it is, when it comes to a Supreme Court justice, every single person on that spectrum wants the same thing. They want somebody who's going to apply the law, who's going to be fair, who's going to treat people with dignity and respect. They want the same things, Betsy. It doesn't matter what the political label is.
The next question is going to come from Rebecca Boone for Senator McKenzie.
Senator, numbers from each district show stark disparities in the average length of probation and sentences across the state for the same types of crime. So for instance, the average length of probation terms given in District 4, which includes Ada County, are about 2 years longer than those given elsewhere in the state. Now, obviously, in your role in the legislature, you're deeply familiar with what lawmakers have been doing for justice reinvestment. I'd like to know if you think the court should address these regional sentencing disparities, and if so, how?
Well, thank you. The court has to be a part of the solution to the issues of justice and incarceration in our state. I was one of the co-sponsors of the Justice Reinvestment Act. I served on the Public Defense Reform Committee. Both of those are reflections of issues that we are seeing as a state related to our incarceration levels and the representation that people have when they go through our court systems. I believe the court has a very important role working with the legislature and the executive branch as we implement the Justice Reinvestment Act. And a large part of that act was to move people to supervised supervision in the communities away from incarceration. And right now there's been rules that have been implemented to put that into place. I think it's going to take some time before we do that and get the funding for different jurisdictions for us to have that. But the court's going to have to work with the legislature, monitor the cases, work with the executive branch to monitor the sentences, and our counties to make sure that the supervision tools are in place for them to do that. It's going to be a long process, but I'm glad that we are looking at it in that way, because I think it's important for our communities to deal with people in an appropriate way, to not over-incarcerate if we can do so safely, and I think we can in many circumstances.
All right, Mrs. Brody, same question to you.
Sure, I think it's important that judges, that if you see a statistic that shows a great variation among the districts in this state, I think it's incredibly important to bring it to the attention of the judges and to talk about it. Figure out, why is it? What's happening within the system? And I think you got to start there. Why? Why is it that this is happening? And from there, you can address what, if anything, needs to be done about it.
All right, the next question comes from Betsy Russell.
Mrs. Brody, you've been endorsed by many high-profile law enforcement officials, including 8 Idaho sheriffs and 18 prosecutors. As a justice on the Supreme Court, how can you be fair to citizens who have disputes against law enforcement?
Betsy, I've handled disputes against law enforcement, and there's a place for it. And it's incredibly important that we recognize that everyone at the end of the day is accountable for what they do. And I believe, as a Supreme Court justice, I understand holding people accountable, no matter what their affiliation is. At the end of the day, that's what's important.
And Senator McKenzie, the Fraternal Order of Police withdrew its endorsement of you for the Supreme Court because you had filed a couple of unsuccessful civil lawsuits against police officers charging excessive force, including a particularly high-profile case in Canyon County in which a suspect was shot. As a justice on the Supreme Court, how can you be fair to law enforcement?
What I would say is, I'm proud of the endorsements that I've got and my friendship with our first responders. But there's no endorsement that's worth more to me than the constitutional rights of one Idahoan. As a state senator, I carried the most significant bills on behalf of the Fraternal Order of Police. I carried the Peace Officers Temporary Disability Bill to ensure that their salary and benefits continued during periods of temporary disability. I carried a bill to protect their identities when they are sued in court, and I worked closely with the FOP to set up the ICAC, the Internet Crimes Against Children Unit in the Attorney General's office, and even this session working with Senator Keogh and Speaker Bedke, who both have endorsed me in this race, to ensure that that remains an investigative unit. I have on my Senate wall my plaque as the FOP Senator of the Year. Next to the plaque is the Fraternal Order, the Firefighter Senator of the Year. I'm proud of the friendships that I have there, but I also believe that the Constitution protects the rights of every Idahoan. So the case that you mentioned, someone who was shot during arrest, I had a case where someone had their clavicle broken during service of a misdemeanor warrant. And then I had a case where a teenage boy was groomed and drugged and sexually molested by a school resource officer. They deserve to have their constitutional rights protected. And I understand and I respect the FOP's protection of its own and to stand up for its members, and they should do that. But I have a different job, and my job is to stand up for the Constitution regardless of my friendship or my preferences.
Mrs. Brody, did you want to respond to that?
I do. You know, I agree that protecting someone's constitutional rights is incredibly, incredibly important. And I'll be the first person to stand up to do that. But I'll tell you what, as lawyers, when we have keys to the courthouse, you have to use impeccable judgment. You have to know what cases to file. You have to know what cases not to file. You've got to use incredible, incredible judgment because there are consequences. And when cases get brought that don't or that should not have been brought, it makes it so difficult for the next person who needs to bring that case to get justice. That's I believe, why the FOP revoked their endorsement.
Senator McKenzie, would you like to respond to that?
Yes, and the case that Mrs. Brody's talking about, I only got involved after it had gone through summary judgment before a federal judge, which is where a judge looks at the facts of a case and determines that it is appropriate to go before a jury. That's when I got involved in that case. And those kind of issues need to be resolved in our court systems rather than other places.
All right, thank you, Senator McKenzie. We have to move on. Rebecca Boone has a question about funding for Robyn Brody.
Mrs. Brody, the courts are currently funded in large part by fees for both criminal and civil cases, but the funding stream isn't stable, and as civil filings particularly have dropped, so does the funding. And so, as a member of the Idaho Supreme Court, if elected, what steps would you pursue to address the declining fee funding and ensure adequate budgets for Idaho courts?
Got to work with the legislature. At the end of the day, they make those decisions. And what I don't want to see us do, I don't want to see us raise fees because I think it creates problems with access to the courts. And at the end of the day, we've got to ensure, and the legislature's a part of that, ensuring that we have a court system that is fully and adequately funded so that we can take care of Idaho's judicial needs.
as a follow, the courts do have some significant discretion, though, over suggesting what fees would be appropriate, when they should be implemented, and some critics say that, particularly the criminal fees and some of the civil, like family law related filing fees, actually put the burden on some of Idaho's most vulnerable citizens. And so in those situations, I mean, should there be another revenue stream?
Well, I certainly can't argue with the idea that those fees put a burden on people. I've seen it. I've seen it in my own practice. I've had to file paperwork to try to get some of those fees waived and things like that, but it's difficult to do. I'd love to see an alternative, but you know, the reality is in a state like Idaho, you know, you've got to work closely with the legislature. You've got to work closely with counties to make sure that you're maximizing the resources that you do or that you've got, and that you're making the best decisions possible. There's not an easy answer to funding problems.
Senator McKenzie, you've seen this firsthand in the legislature and the struggle to fund the courts. What do you think needs to be done?
Well, I've worked with Patty Tobias, who was the court's lobbyist, on a number of issues related to compensation for district judges, to putting our senior judge program in place to utilize judges who had retired back in our court system. And I've worked on some of the other things I talked about, the FOP bill. And these things often get put onto fees and costs. And as you say, in criminal context, sometimes they don't get paid. If a person's sent off right to prison, it doesn't get paid. In the civil context, it can be very, very expensive now, and we're having fewer filings. And so this is going to be an ongoing issue that the court, the legislature, and the counties, because they're involved in the public defense system so heavily, are going to have to resolve. And I think the fees and costs that we talked about are going to be a component of that, but you cannot keep adding to those in order to pay for the system. And so it's something we're going to have to look at, and all three branches are going to have to work together to make sure our courts are accessible, but we're paying for the things we need to pay for.
All right, the next question comes from Betsy Russell for Robyn Brody.
Mrs. Brody, both of your practices reside in areas where the new Odyssey system, the new paperless system, has been rolling out for our courts. What has your experience with that been, and what would you want to change moving forward, briefly?
Right. I love electronic filing. I've been practicing primarily in the water courts over the last 5 years, and I'm spoiled rotten. I love it. I think it makes life a lot easier.
Senator McKenzie, same question.
Well, you know, I've utilized it mostly in the federal court system, where it's all electronic filing, and now Ada County is doing that as well, and just starting it there. I do think it's an important tool to gain access to the courts. Records are more accessible to people. It's easier to file once you figure out the system, and the notices that go out are easier for the attorneys to follow and to find out when their deadlines are. So it's an important process that we're just starting to implement in Idaho, and I'm very familiar with it from having practiced in federal court, and I'm glad to see we're doing it at the state level, and we're going to continue to expand that throughout the state.
Mrs. Brody, part of one of the aims of this new system is to make court documents more widely available to people all throughout the state, just as they have been in federal court through the PACER system. Although we're not there yet, how do you view that kind of transparency, and what should we be doing as far as transparency in our courts?
Well, I think it's incredibly important that people have access to the documents themselves. And I know I've had conversations with Steve Kenyon, the court clerk, actually about the Odyssey system and about when the court will be moving to actually making those documents available. Right now, of course, the court's getting all of the filings actually taking place online, and once that is up and rolling, I know the court's going to be wrestling with the issue of how do we best deliver actual access to the documents themselves, and I'm excited to be a part of that discussion. You know, I'm a PACER user myself, and that's the federal filing system, and I'd love to play a role in making some of those decisions.
Senator McKenzie, how transparent should our court system be? How easy should it be to get those records for people across the state?
Well, in publicly filed cases where they're not under seal, they should be very accessible to the people. And here in Idaho, we're used to a system that's like that because of the federal court system, where it's very easy to get copies of documents off the PACER system in PDF form. And I think that's a very useful thing. And I'm glad to see that in Idaho we're starting to go in that direction and really making those records more accessible to everyone.
Real quick, one last question. Justices to the U.S. Supreme Court are appointed by the President and approved by the Senate. Should the decision as to who serves on the Idaho Supreme Court be left to the voters? And we have less than a minute for both of you to answer. Mrs. Brody, you go.
You know, I'll take my chances with the Idaho voters every day of the week.
Senator McKenzie.
You know, I believe we have the right process for Idaho. We've seen how political that appointment can be at the federal level, and I trust the people of Idaho to make the right choice for Idaho.
Okay, that's about all the time we have for questions. See, that was fun. We didn't even have any lawyer jokes that we had to tell. That was great. It is time for closing statements, and Senator McKenzie, you won the coin toss. You go first.
All right, thank you, Melissa. And again, I want to thank our hosts for having us here, for each of you who've watched this. I believe that the background that I have in the legislature, it's given me a perspective on the separation of powers, is an important one for someone to have on the court. In Idaho, we have a long tradition of those having served in elected office also being on our court. And it's an important role for a justice to have, to understand that their role is fundamentally different than setting policy in the legislative branch. I have a strong academic background. It's started here in Idaho, was at Georgetown where I met Justice Scalia. I started to understand the philosophy that he applies to constitutional cases, which I believe not only applies to the Constitution, but every issue that comes before the court. There should be predictability under the rule of law, and I will protect that for all Idahoans. Thank you very much.
All right, thank you so much, Senator McKenzie and Mrs. Brody.
You know, I've put together a county by county organization to help me run this race. And when you look at that list, there are Democrats, Republicans, Independents, Tea Partiers. There are men, there are women, there are young, there are old, there are blue collar, there are professionals, there are teachers. And I am so proud of the broad support that the people of the state of Idaho have given to me. It's the best part of this race by far. The issue that we have here is one simply of experience. Experience matters because at the heart of experience, that's what creates good judgment. Having the broad background and the depth is incredibly important. Meeting Justice Scalia is an inspiration, but it's not a qualification for this job. I'm the person who's the right person for the Idaho Supreme Court.
All right, thank you to both of our candidates. That's all the time we have for tonight. Senator McKenzie, Robyn, Brody. And thank you to our panelists, Rebecca Boone of the Associated Press and Betsy Russell of the Spokesman Review. Remember, the election is November 8th and you can vote early through November 4th. For more information on voting, including how to register and where to find your polling place, call your county clerk's office or visit idahovotes.gov. Thanks so much for watching. Good night, and we'll see you at the polls.
The Idaho Debates is a collaborative project of the Idaho Press Club, the League of Women Voters of Idaho, Boise State University School of Public Service, and Idaho Public Television. The Idaho Debates are brought to you by contributions to the Idaho Public Television Endowment.